I have with me here is contract redlining etiquette. What kind of gave you the initial desire to go down sharing your insights and ideas around best practices in contracting generally?
On this episode of Executive Edge, Simon welcomes Nada Alnajafi, attorney, best-selling author, and founder of Contract Nerds.
Nada breaks down the art of smarter redlining, shares how she built a global contracts community, and explains why clarity and collaboration are the real power tools in negotiation.
The foundation for the book is 10 steps. How did you come up with those initially?
Beginning of the book was that first post on LinkedIn, which said to use explanatory comments with red lines. That actually became rule number 1 of contract redlining etiquette. At that time, I would say using comments was not the majority practice. By using explanatory comments, you absolutely are speeding up the time to close. You're creating clarity between the parties. It's way more collaborative. Just like in negotiation, there are different styles. There are also different styles in redlining. So you can be more of a competitive redliner. It's a take it or leave it mentality. And then there's the more collaborative redlining approach, which is actually using the comments and the margins to ask clarifying questions.
Where's the contract nerds out there? Are they out testing redlining AI tools?
AI is so new, and lawyers in particular are not very good with change or technology adoption. It's definitely here, and it's definitely going to change the way we redline contracts.
Hi, everyone. Welcome to another episode of Executive Edge, here with your host, Simon Rycraft. Excited to have with me Nada Alnajafi. Thanks for coming on, Nada. Thank you.
Thanks for having me.
Nada's an attorney, founder, author, keynote speaker, thought leader, contracts expert, redlining expert, and mentor. Nada currently serves as a senior corporate counsel member for Franklin Templeton as a Fortune 500 global financial services organization. She's part of the buy-side contract review team, is responsible for a high volume of commercial technology and data privacy agreements for global clients. Nada's also founder of Contract Nerds, which is how I found out about her through some mutual friends, which is a blog for in-house counsel and contracts professionals around the world, and an author of an amazing book, which we want to get into in a little bit of detail. And I have with me here is Contract Redlining Etiquette. For anyone who might be interested in learning a bit more, it's a #1 bestseller in contracts law on Amazon. And it's a fun read. We were talking a little bit before we hit record on it's one of those topics that really isn't talked about, but people do it on a daily basis, right? I mean, so understanding best practices, sharing best practices, following guidance from an expert on good approaches is pretty important. So, all right, let's jump in, Nada. How did you get started in this? Obviously, legal law professional as a background, but what kind of gave you the initial desire to go down a rabbit hole of kind of sharing your insights and ideas around best practices in contracting generally?
Yeah, so I had been practicing for almost 15 years as mostly an in-house attorney and spending all day long working with contracts. So that really became my bread and butter. And when the pandemic came in 2020, I found myself, like many, with more time on my hands than usual. And just being sort of like career driven, I was thinking, okay, what can I do career-wise to really give back to the community. I love teaching. I love writing. And so I went on LinkedIn and I saw that there was this trend that started happening where lawyers were starting to be a little bit more public facing than usual, where they were offering tips and techniques and asking really important questions through LinkedIn posts. And I thought, well, what do I consider myself an expert in? And just having worked with contracts so long, that was an easy answer to that question. And then I did my first post on LinkedIn, which was a tip for in-house counsel. And it said, in-house counsel should be leaving explanatory comments with your proposed red lines. Okay. And that got a ton of engagement. And I could tell that there was this need for more information and education around that topic because I learned everything I know about redlining and about contracts just on the job. Even in my Contracts 101 class in law school, I didn't look at a single contract. We were talking all theoretical.
Yeah.
And so it was kind of like a lonely and long journey when it really, I don't think it should have been. And that's when I started thinking about, engaging more on LinkedIn, and then building a community that would really help make that learning process and that career success something easier for folks to achieve than it was on me, because I had a bit of, a windy road to get here. And then I came up with the name Contract Nerds, and it all sort of took a life of its own from there.
Yeah, super cool. I mean, what's fascinating to me, and this really hit home when I first saw your profile, and I saw or actually listened to a podcast that you joined a couple of years ago, and then got the book. It's so fundamental, right? Like most people, and I include myself in this group, assume contracts are this piece of paper, right? Often, a lot of the times, longer than it needs to be. It's standard language, right? These are legalese. Leave the attorneys to it, once the deal's been negotiated. But the reality is, when you're going through a commercial negotiation, the contract terms are a critical part of that. And, when you're doing large deals, you're doing the back and forth. It's actually part of the negotiation. It almost becomes the trade sheet, an evolving trade sheet that's used throughout negotiation before a contract's finally signed.
Mm-hmm.
And then it's the negotiation output is memorialized and and set in stone based on what's written in that contract. So it's fundamental, right? So anyone who is a negotiator, right, and they actually need to negotiate for their job, should understand at least some of the basics that you have in your book. Even if you're not a trained attorney, even if you're not a paralegal, to even have the conversation with the legal team. And so many firms don't have legal teams, or they have in-house counsel, but that counsel doesn't have the bandwidth to support them. So they need to be able to do some of this basic stuff and then just go to them for the larger deals, the larger contracts, or when some of the redlining's happening, right? So I think doing this properly, some of the details and the 10 steps in your book could have a material impact, at least in my view, from my experience, in the outcome of a negotiation. I mean, have you what's the community feedback been since your book, since you've grown the ecosystem? Is it just attorneys that share interest in their own experiences and kind of joined your blog, or is there also paralegals and then commercial and then procurement people have all jumped in as well? Like what's the mix that you engage with?
Yeah, great question, Simon. Contracts are for everyone, not just attorneys. So, for example, the Contract Nerds community and the audience that I wrote my book, Contract Redlining Etiquette, for is broader than just attorneys. So it does include in-house counsel, outside counsel, big law attorneys, private practice attorneys, but at the same time, procurement professionals, sales professionals, contract managers, legal ops professionals. And then there's also different business functions that work with contracts, like marketing folks. They tend to draft the SOWs for marketing consulting agreements, and HR teams are looking at employment agreements, not just attorneys. And so we have a really nice mix of this big community of people who, in their work life, they work with contracts. And in terms of the book, I think what makes it so popular, because we've sold almost 10,000 copies, is that never before have we had a book or a formal training or a course on the topic of contract redlining. There's contract drafting, there's contract management, but there's not a focus on the redlining portion of it itself. And that's a really important component of the entire contracting life cycle, because that's the part that takes the longest, that redlining back and forth. And if I'm doing it one way, and let's say you're up for the other party and you're doing it another way, we're going to miss each other a lot. We're going to have a lot of miscommunications. We're going to each be doing things kind of our own way. Document themselves gets very messy, and it can take time to clean up. In all of that, we lose focus of the deal itself and of building the relationship. Because when we're getting frustrated, or when we are feeling like we're wasting time, it's not good for the relationship either. And so what I really like about the focus on contract redlining etiquette is efficiency, transparency, and collaboration. And that's really what all 10 of the rules and all of my tips always go under one of those three main goals that we're trying to meet.
Okay. Yeah, no, I love that. And then the foundation for the book is 10 steps, and those kind of distinct learnings, right? Hacks or tricks.
Right.
How did you come up with those initially? Are those things that just intuitively you and majority of contract professionals were already doing, and you just put it down and synthesized it, to the layman and less legally trained mind? Or were these things that you kind of, as you were writing the book, synthesized, and maybe it's changed the way that you negotiate contracts now as well?
Yeah. So I wrote the book over a 2-year period of time.
Okay.
The beginning of the book was that first post on LinkedIn, which said to use explanatory comments with red lines. That actually became rule number 1 of contract redlining etiquette. So from that
Okay.
single post, I was, reading and studying all of the feedback and the comments and the questions. People really wanted to talk about this point. And at that time, I would say using comments was not the majority practice. It was the minority practice. But when I used explanatory comments, I saw what an impact it had on the deal process and the time to close. By using explanatory comments, you absolutely are speeding up the time to close. You're creating clarity between the parties. It's way more collaborative. And you can even use the comments to help your business clients understand the contract a little bit better. So there's that internal alignment component to it as well. Just so many benefits for that one tip. So then I wrote it into a longer article, and I put my ideas and the questions, I tried to answer them, and then the feedback from what the community was saying about it, because I didn't want the book to just be what Nada thought redlining should look like.
Mhm.
It should be truly what drives efficiency, transparency, and collaboration. And I wrote it in the article, and then I published the article through Contract Nerds, and then the article itself gets comments on it. So then I'm adapting, and I'm basically increasing the length of that article, which became a chapter.
Okay.
And then I did rule number 2, and I posted on LinkedIn, and then I write the article, and then I write the chapter. And I did that for each of the 10 rules. And that's why it's really, it truly is a reflection of community practices, best practices, and things that actually work.
That's super cool. I don't know if I've heard anyone do that, or at least successfully, right? Where it's ended in a published product. Yeah, I love that. So what about I think the collaboration piece is pretty key. So from a commercial perspective, I've done very large BPO deals. I've done large, investment round agreements. I've done large purchase agreements, right, for clients as well as prior businesses in the past. And one thing that I guess I don't think I initially appreciated early on, I actually probably made some mistakes on, right, and then you kind of learn from those failures, was the importance of that collaboration, right? And this was some of the earlier stage deals were before there was tools like Teams, and SharePoint was clunky, and you'd have to check the document out, and stuff would get overwritten. So just the discipline in the process, because you've got the risk team, right? You've got the internal key stakeholders, you've got attorneys, in-house, out counsel on both sides, right? Commercial leaders. There can be quite sizable teams that are involved at different stages of the contract drafting, right, until something is completely finalized. I think that to me is, it's fundamental, and something I really appreciated from the fact that this book even exists, or the practice, right? I know that your business is not just necessarily the book; there's a whole community and sharing of ideas, but that collaboration piece shouldn't be underestimated. So it's how do you get that across in some of the conversations that you have? Is the fact that it's not a redlining debate between two people, right? Is that you can have 10, 15, even larger deals, 20 people are wanting input on the latest version of something. How do you get that point across? And is that a common issue that you see in what you've done?
Yeah, I think there was sort of this, false assumption that when attorneys are negotiating, they're going to be competitive in their negotiations, that we're sort of trained to always like push what our client wants, and we don't really care about what the other side wants, and it's difficult for us to find creative solutions and be collaborative. We're very one-sided. But as an in-house attorney, and when you're working on commercial agreements, you shouldn't be so competitive. You should be more collaborative, because at the end of the day, you're building a deal where two companies want to be working together and both of them want to be successful in that deal, right? And so just like in negotiation, there are different styles. There are also different styles in redlining. So you can be more of a competitive redliner where you just redline their entire document and you send it over and you say, this is all we can accept. And you don't have any explanations, and you don't ask to get on a call, and you're not interested in clarifying their position. It's a take it or leave it mentality. And then there's the more collaborative redlining approach, which is actually using the comments and the margins to ask clarifying questions. Can you help me understand this point? Can you give some clarification on why you struck this, but then in this clause you said this here? Or it looks like we need a little bit more conversation on this particular clause. Why don't we discuss on a live call? And so now what we're doing is we're not jumping to conclusions, and we're not even taking a position yet. We're just trying to understand a little bit better. And that understanding gets us so much closer together than if we're just taking these hard positions. And sometimes I think that can get lost in documents. Like when texting first came and email, there was this conversation about the tone. Be very careful with the tone of how you're writing things, because you can say something in person and you can write it and the tone will come off completely differently. I think it's the same with redlining. You have a lot of words on one page, and then you have these different colors, and red can sometimes stress people out or make it look like that's incorrect or that's rejected. So your comments that you're leaving soften that message up, and they really help you deliver no's a little bit softer or ask more questions. And I've found that when you have that conversation piece, people are way more likely to agree with you than they are if you're just asking for something and sort of demanding it without even explaining why. So I think that documents and using red lines can really help drive collaboration when it's used the right way.
I love that. And then one question on technology. I hate to bring up AI in every conversation right now, but unfortunately, it's tough to at least avoid it. Where are you at? Where's the contract nerds out there? Where's their point of view? Are they out testing redlining? AI tools? Are there any that our community should keep an eye on, but wait until have been vetted out a little further? Are there things that you're excited about or advising on potentially as well?
Yeah, so we actually just took a poll yesterday on a big webinar we had with almost 1,000 attendees, and we asked them, where are you in the adoption of AI to redline and review contracts? Cool. And most respondents said that they're in the shopping phase. So they're either looking at demos or they're doing an RFP to do a pilot to select one that they're going to use. So that was the majority response. Very few said that they were not even considering it. That was probably the least popular response. And I'd say I'm similar in my path where I am right now, which is I'm looking at the market to see what's available. And I've done several AI review tool demos. Okay. And I think what I'm seeing in terms of functionality is that a lot of them have a lot of overlapping functionalities and capabilities. What it really comes down to is the quality of the red line. So, the quality of the contract database that the tool has been trained on. Some companies have hired entire law firms to create templates and playbooks and to train their AI, and others haven't. In addition, I think another distinguishing point is the type of customer service being offered. AI is so new, and lawyers in particular are not very good with change or technology adoption unless you are in the community and that is something you are passionate about. And so I think it's really smart for AI vendors to have that customer service mindset where some of them will even help you create your playbooks or your templates and really give you that white glove service, which I think really goes a long way in educating and getting that user adoption. Because it seems easy, like, oh, it's just a Word add and all you have to do is sign in, turn it on, and use it. But lawyers and contracts professionals will want to go deeper than that. We really do look at the details and where every comma is placed and what word is used and how is it presented and what will it come off like to the other party and are the terms benchmarked to market standards, things like that. So there's a bit more of research that I'm doing before I think I take a hard position on it, but it's definitely here. And it's definitely going to change the way we redline contracts, where I think we'll be using AI as sort of like another collaborator in the document. So it will be like me from legal, let's say someone from the business side, someone from compliance, someone from data privacy, and AI. And it'll be a co-collaborator with us is kind of how I see it.
I can imagine that being the way that it plays out, because there's still the accountability and the responsibility of a trained professional to make the QA, QC, ultimate risk assessment, before a contract's formally signed. When are we going to get to a point? And are these vendors, are they all brand new? Are you starting to see these features from existing matter management software providers as well, or are they kind of a little slower to the table?
There are a number of brand new meaning, like, let's say in the last 3 years, vendors who focus specifically on AI review and redlining.
Interesting.
And then there are CLM, contract lifecycle management companies, that are those larger end-to-end systems that now are including the AI review component into their native system. And I think that's great when you see a CLM that has that know-how in AI. Not all of them do. And then there are some generative AI tools like chat functions, like even Copilot is inching in towards contract review or contract summarization. So it can do probably some basic review and summarizing and maybe like, can you tell me what a better clause might be for this? But you don't have that deeper legal training in those kinds of tools. So it's really, I think there's a lot of options on the market right now. And I think folks first need to ask themselves, what are your pain points? What are you trying to use technology to solve for? And then go out and do the demos. Because otherwise, if you're just demoing without knowing what you need, I think you could easily get lost in all the different options.
One thing, I don't know whether there'd be huge value in this, but one thing I think I'd like to see would be something around the alerts of tracking of changes, right? Kind of basically highlighting, changes that haven't been tracked or any version control issues. Because I've definitely faced that a few times in the past and made the mistake myself. We're just in saving the document and, and sharing the wrong one, or not making a change in one version versus the one that's shared. And do you miss stuff potentially, right? Whereas software might pick that up, especially for really complex legal documents. That might save some time, I guess.
I think AI is helping us with that, and it's improving those document comparison tools. And then a CLM platform that has AI and the doc comparison feature. Some of the ones I've seen really do help you with version tracking and keep it nice and organized. And I think that definitely reduces the risk of disorganization or documents getting lost, or even an internal party sending an internal version out externally, which could be a risk and potentially waive attorney-client privilege or attorney work product. So version control is one of those things where you're like, okay, that just seems so common sense, but it's actually, takes quite a bit of organization and mindfulness to make sure that you're managing it appropriately. Otherwise, you can spend way too much time finding a document, and that I would consider an inefficient use of the professional's time.
Yeah, for sure. and a margin for human error as well, which is pretty important for some of these deals. I enjoyed geeking out on this just as much as I thought I would, so I wanted to say thank you again. A reminder for the other people that watched or joined late and didn't see the book, Contract Redlining Etiquette, or CRE for short, and definitely take a read of it. I think anyone, even up to legal counsel level, COOs, investors, and definitely procurement professionals and sales as well would benefit from understanding a bit about the approach and brushing up on their skills, even if it means they just have a easier time having conversations with the real professionals and the attorney group. So thank you very much, Nada, for your time. Appreciate it. I'm glad that we were able to chat, and hopefully we could have you on again at some time in the future.
Thank you.
Thank you again.
So much, Simon. Thank you. This was really fun. I really appreciate it.
Okay. All right. Awesome. Thank you.